As a general rule, assets acquired during the marriage are considered to be community property and in a divorce are divided equally. Any property that you brought into the marriage or that during the marriage you received by gift or inheritance is considered separate, and that does not get divided. On accounts, if all of the money in the account was earned during the marriage, that's going to be community property and it's going to be divided equally. However, if some of the money is separate and some of it's community, there's going to have to be an allocation that's going to require a tracing of the separate money. On businesses, if the business was started during the marriage, it's going to be community property, and that will also be divided equally. If the business was opened prior to the marriage, the community may still have an interest in the business depending on a number of factors, but again, that's going to have to be determined usually through the assistance of experts. On the issue of stock options, that's a much more complicated question, but generally the important dates to remember are the grant date and the vesting date for the stock options. If the stock was granted and vested during the marriage, it will be community property and will be divided equally in the divorce. If, however, some of the stock was granted prior to marriage and then vested either during marriage or after separation, there's going to have to be an allocation between separate and community, and again, we'll normally use an expert to perform that analysis. Since there are many serious and difficult issues relating to the division of property in California, it's usually a good idea for someone to consult with a knowledgeable family law attorney so they have a very clear picture of what their rights are in your specific situation.